Well, I'm in the middle of recording an audiobook, and I just thought it might be helpful to share this with our team on Facebook as well. This is kind of the process it takes to be productive all the time. You see, I bought this microphone and all these computers and so on and so forth so that we can share our message to as many people as possible. When I talk about being resilient, I mean, don't just talk about it, you got to be about it. You got to create as much possible content as you can possibly create. So while I'm recording this book or parts of this book into what's called an Adobe Audition file that I will later mix for an iTunes podcast. It's the Prison Professors podcast. I am also recording live on video while I'm in shelter-in-place environment. So I'll just record a little bit of it so you can kind of see the process, because I thought it might be helpful for some people to see the process of what it looks like. And I'll publish this into our Being Resilient Facebook page with hopes that you too will work toward being resilient, with hopes that you will work towards inventing yourself in this new work from home climate that we all have to master. You know, you've got to figure out how you can do it. That's what I'm doing. I never ask anybody to do anything that I'm not doing. And if I talk about being resilient, I'm serious about it. So I'm only going to read a few minutes of this, record a few minutes of this, or until I make my first mistake where I would ordinarily cut. Just so that you can see how the process works. So I already have my manuscript up on the screen, and now I'm taking my mouse and moving over the manuscript, and I'm just going to start reading. So I won't be able to see how I'm doing anymore, but I want to show how it works. So let's track that. This chapter is chapter 4 of the book, Prepare What Defendants Should Know If They're Facing Court, Sentencing, or Prison. And I'm going to be reading chapter 4, and the title of chapter 4 is What Are Criminal Justice Proceedings? So the first thing I'm going to do, because to block the video recording versus the audio recording, is and that's going to let me know, sorry about that if it was too loud for you, but that's going to let me know this is where I have to start the edit when I begin the podcast production. So, what are criminal justice proceedings? Hopefully, once you find and hire a lawyer, you will have a trusted advocate. When it comes to criminal matters, unfortunately, finding and hiring a criminal defense attorney is only the start of a long and arduous path. The more a defendant learns about the challenges ahead, and the better he understands how he can prepare, the more likely he will be to conquer struggles that complicate life for so many that experience the criminal justice system. I don't have precise statistics in front of me. Still, I don't think anyone will argue that federal prosecutors bring criminal charges against individuals for one reason. They want to get a sentencing hearing. They know that a sentencing hearing will follow more than 6 out of 10 times. Now, before banging the gavel to signal finality, the judge is frequently going to say, "I sentence you to the custody of the Attorney General." Now, several years ago, a federal judge in the Southern District of California invited our team to lead a panel discussion for other judges in his district. They wanted us to help judges understand what happens after they sentence a person to prison. If federal judges don't know what happens after they sentence a person, it's fair to say that neither lawyers nor defendants know what to expect either. In fact, some defendants don't even know how they got into the system. That's the reason that we wrote this book, Prepare What Defendants Need to Know About Court, Sentencing, and Prison. So let's start with a discussion on how it all starts. Relatively few Americans have more than a basic understanding of our nation's criminal justice system. They know that law enforcement officers arrest people. They know that district attorneys prosecute many of those who are arrested. And some people who are convicted go to jail or prison. Of course, it's much more complicated than that. Although I'm not a lawyer, I've done a lot of research to get better understandings of the system. And I found an excellent resource in Modern Criminal Procedure, the 9th edition by Yale Commissar. In fact, I read that book probably when I was in my, 8th or 9th year of imprisonment. It's when I found it in the law library, and I continued reading it year after year because it's such a great resource for anyone that wants to get a more thorough understanding of the system. Now, most people don't need to read a legal treatise. The summary I provide below or in this audio podcast will give most defendants a better understanding of how the criminal justice machine works. And if you're watching this on our Prison Professors YouTube channel or on our Being Resilient Facebook page, you will also get an understanding of how the system works. You see, that understanding is what's going to lead to more fluency, better communications, and better preparations for the journey ahead. Now again, we're preparing this document for the layman, for people who want to get a brief glimpse of what to expect if authorities have charged them with a felony. So we want to start from the premise that our criminal justice system is designed to protect society. It doesn't always seem that way for a defendant. When a defendant comes into the system, everything feels like a personal attack, and the complicated proceedings aren't always easy to understand. Lawyers talk about substantive laws, and those are the laws that Congress passes, and they talk about proceedings, which are the rules by which the system is supposed to operate. It isn't a perfect system because it has evolved over multiple decades, and it is designed to operate at scale. A system to process more than 1 million people each year doesn't look too closely at personal characteristics and circumstances. It's much more like moving a cog through an elaborate machine. And that's a concept that's very difficult for a lot of people who come into the system to really understand. Many people complain that law enforcement officers and prosecutors operate outside the scope of the rules in order to get convictions. Unfortunately, complaining doesn't solve any problems. Once a person comes into the system, it is best to think methodically. We need to learn as much as possible and then engineer our way to the best outcome. So throughout this recording and the courses that we build, we offer insight that anybody can use along with their attorneys in their efforts to prepare. Now, practically speaking, defendants would be well advised to expect law enforcement officers and prosecutors to use every means available for them to achieve their ends. Ultimately, prosecutors want to solve crimes and they want to convict. Now, in a perfect world, those representatives of justice would dot every I and cross every T as they follow the rules in both the letter and the spirit of the law. But years of working with society's felons frequently causes seasoned law enforcement officers to develop cynical perspectives of humanity. Sometimes, to get the outcome they want, they cut corners. They may even threaten. Let me give an example from a client that our team is working with now. Sam is a healthcare professional. So the prosecutor offered him an opportunity to plead guilty to a charge with a 5-year cap. Now, if Sam chose to exercise his right to a jury trial, the prosecutor threatened to bring charges against his wife and to bring further charges that would expose Sam to more than 20 years in prison. Then, the prosecutor argued that Sam would have to agree to say that no one pressured, threatened, or induced him to take a plea. So even though the prosecutor is threatening to bring his wife into the system and to charge him with crimes that could bring him effectively to a life sentence, the prosecutor also wants him to say, but it was all done in the spirit of fairness. So from Sam's perspective, the proceeding is inherently unfair. He would like to have had the opportunity to argue for his innocence, but he couldn't afford to expose his wife to the threat of criminal charges. He felt threatened and pressured to take the deal. Rather than justice, Sam said the prosecutor wanted a conviction. And those who work in law enforcement tend to become ultra-conservative. They may be rigid in their beliefs that people who are charged with crimes clearly did something wrong and they ought to be punished. Such attitudes can result in offenders being charged with crimes that can result in convictions, as opposed to the offender being charged with precisely the activities that the individual may have actually committed. Now, it would be wise, I think, for those who become entangled with the criminal justice system to anticipate that the system is influenced much more by Machiavelli, pursuing victory regardless of methods, rather than a system influenced by teachings of more enlightened leaders that encourage forgiveness, compassion, and concern for the individual. So the more we understand about that, the better we can decide, the better we can make decisions. And if we make better decisions, we can influence an opportunity to recalibrate, to get back on our feet and get back to our lives at the soonest possible time. We just have to understand as much as possible. Now, in compliance with our nation's Constitution, legislators elected to both houses of the U.S. Congress have played a significant role in establishing a body of federal laws that are supposed to govern the behavior of citizens. And the U.S. Constitution also provides legislators from each state with authority to establish their own code of criminal laws for their state and their own criminal justice process for enforcing those laws statewide. Although the different jurisdictions frequently collaborate, our nation actually operates several different criminal justice systems. We have a system for the federal government, we have a system for each of the 50 states, we have a system for the military, and we have another criminal justice system for the District of Columbia. Now, it's our responsibility as citizens to abide by these laws. When we don't, we subject ourselves to being charged with criminal offenses and experiencing the wrath of the criminal justice system. Law enforcement officers are supposed to follow strictly prescribed procedures when charging a citizen with wrongdoing. And in addition to federal and state rules for criminal procedure, published judicial opinions may also have an impact on criminal procedures. And I hope this isn't too complicated. If it is, you can just download this book by visiting our website at prisonprofessors.com. But I'm going to continue reading. Criminal procedures are complicated. They can be understood more easily when we think of the criminal justice system as a game. And I use this metaphor for clarity, not to trivialize the conflict between the accuser and accused. Offenders or defendants act as opponents of law enforcement officers and prosecutors. Both sides want to win. The defendants want to be acquitted or to receive the least restrictive sanction. And on the flip side, law enforcement officers and prosecutors want to convict. They frequently argue for defendants to receive severe sanctions without consideration for individual characteristics or mitigating factors. A judge will make the ultimate decision. And in this game of criminal justice, the judge acts as a referee. Judges are charged with the responsibility of ensuring that all participants of the game follow procedures to ensure that due process is achieved. Although there are many ways this game may begin, it usually starts when someone reports a crime to a member of law enforcement. So what happens next? Well, once the crime is reported, the criminal justice process usually begins, and it is otherwise discovered by law enforcement officers. Law enforcement officers may learn about a crime in any number of ways. Maybe they're going to observe a crime being committed. Maybe they're going to learn about it because someone reports it. Maybe they're going to learn about it through some type of investigation or interrogating others. But once law enforcement officers learn about a crime, it becomes a reported crime or a known offense. So what happens next? Well, first there's a pre-arrest investigation, unless it's something that happens in hot pursuit. Now, sometimes, as when law enforcement officers are present when a crime is being committed or soon thereafter, the investigation begins with an on-the-scene arrest, right? They witness a robbery being taken place. Other times, like when an officer learns that a crime has been committed, but they were not in a position to make an on-the-scene arrest, they have the responsibility of solving that crime. They therefore launch a reactive investigation where the officers will attempt to figure out whether a crime was in fact committed, who committed the crime, what evidence there was of guilt, and how to locate the offender to make an arrest. Now, proactive investigations are different. They are aimed to solve crimes that are ongoing, and they may take place in the future. These types of investigations place law enforcement officers in a position to uncover criminal activity, the specifics of which are not known, or where they do not have enough information to charge all who may have been participating in the crime. Another type of pre-arrest investigation includes the prosecutorial investigation, which is generally conducted by a prosecutor, like a U.S. attorney. The prosecutor has the power to convene a grand jury. And later in another chapter, I'll talk about a grand jury, or maybe it's in this chapter. But through the power of the grand jury, they can issue subpoenas. And individuals who receive such subpoenas, those subpoenas must appear before the grand jury and answer questions, and the prosecutor poses as the prosecutor poses during this criminal investigation. Now, since the person who received the subpoena does not have counsel present during the questioning, and the entire grand jury proceeding is orchestrated by a prosecutor, it has become routine for grand juries to rubber stamp the recommendations of the prosecutor. In fact, the famous litigator from Harvard, Alan Dershowitz, wrote in one of his books, a good prosecutor could indict a ham sandwich, meaning it's a perfunctory matter. When they want to get an indictment from a grand jury, prosecutors only have to ask. So another stage in the proceedings is the arrest. Now, an arrest occurs when the law enforcement officer takes a person into custody. Sometimes the arrest occurs at the scene of a crime. In cases that evolve from a reactive or proactive investigation, on the other hand, the officers will obtain an arrest warrant, usually from a magistrate judge. Now, before taking the person into custody, they have to get that warrant. But in some cases, officers will allow the suspect to turn himself in. And in other cases, law enforcement officers will make a spectacle. In those cases, the officers use an extreme show of force, frequently with weapons drawn, at an inconvenient time, like the break of dawn, or during a person's work hours. They'll make a show of force and come in to like a brokerage office for if they want to nail somebody for securities fraud, or they'll come into the doctor's home at 5 o'clock in the morning and wake with a lot of noise and fanfare. So we understand how that works. What's the next step is booking. Once the arrest takes place or the person's brought into custody, the officers will search him. They may search his vehicle, his home, his office, wherever they find him. And they're looking for contraband, weapons, or evidence of a crime. Then they transport the suspect to jail, a courthouse, or some other type of holding facility for further processing or booking. Now, during the booking procedure, the officers will conduct clerical procedures to memorialize the arrest. They record fingerprints and photograph the suspect. This is the well-known mugshot. And if it's a minor crime, authorities may release a suspect from the holding facility. But if the alleged crime is more serious in nature, authorities may hold the suspect for several hours or even days until he can appear before a judge who will determine whether bail is appropriate. Now, if the person's held in a lockup, it's likely that he'll be ordered to undergo a strip search. It's just part of the journey. Now, then there's the post-arrest investigation. So immediately after the arrest, the post-arrest investigation begins. The first step is when the officers search the person and possibly his vehicle, home, or office. They're looking for evidence that they can use against him. After that, law enforcement officers may conclude that little else needs to be done in the event that they caught the suspect in the act, or they may continue with many of the same types of techniques used in reactive and proactive investigations, such as interviews and searches. So then, the prosecutors make a decision to charge. When law enforcement officers witness a crime, they make a decision right then and there whether they're going to charge the suspected offender. Then, after the individual has been processed through booking, superior officers may review the arrest and decide whether to allow it to proceed. If the law enforcement agency chooses to proceed with prosecution, the prosecutors will then review the charge. And the prosecutor can again interview the arresting officer and review the evidence to determine whether the case is worthy of filing a criminal charge. Now, reasons why a prosecutor may decline to file the charges include insufficient evidence, witness difficulties, due process problems, alternatives to prosecution may be more appropriate, and there may be diversionary programs that enable the suspect to avoid a criminal record. You may remember the notorious case of Jeffrey Epstein, the guy who killed himself inside of the MDC, was it Brooklyn or MCC New York? But he hung himself, but his prior proceedings were almost a diversionary program, so he avoided what most people would have resulted in a lengthy prison term. But even if the prosecutor initially chooses to charge an individual, he may change his decision. And if he determines that the charge is not justified or that a lesser charge is more appropriate, in those cases, the prosecutor would have to file a motion before the court detailing the prosecutor's reasons to forego prosecution. So the prosecutor has to use the same screening factors identified above to determine the appropriateness of such a motion. But once the decision is made, they have to file the complaint. Now, in many cases, If the charges pass the prosecutor's screening, the next step comes when the prosecutor files the criminal complaint. And he files it most likely with a magistrate judge. The complaint, and that's in the federal system. The complaint is usually a fairly brief document, concisely detailing the criminal allegations. When a complaint is used as the charging instrument, someone must sign the complaint under oath, indicating that he or she believes the factual allegations of the complaint to be true. Usually, it's the victim of the crime or the investigative officer who signs the complaint. And the filing of the complaint, once that happens, the suspect now becomes a defendant in a criminal proceeding. And once that happens, there is a review of the magistrate generally by a magistrate or a judge. So many jurisdictions appoint the magistrate judges to take some of the workload away from the trial judges. Now, among other things, the magistrate judges handle many of the pretrial matters. After the prosecutor files the complaint with the court, but before the defendant's first appearance, for example, it will frequently be the magistrate judge who reviews the charges against the defendant. If the defendant was arrested without a warrant and remains in custody, the magistrate must determine whether probable cause exists for the defendant's continued detention. In the extremely rare case where the judge finds that the prosecutor has not established probable cause, the prosecution must either produce more information or release the person. So then we go to the first appearance. With the filing of the complaint, the defendant is brought before the judge without unnecessary delay. Several hours or several days must pass before the defendant sees a judge, depending on the circumstances. If a defendant is arrested late on a Friday afternoon, he may not see the judge until the following Monday. The first appearance is generally a brief proceeding in which the magistrate determines that the person named on the complaint is the person before the court. After the magistrate judge is convinced that the appropriate person is present, the judge will read the charges made against the defendant, identify the defendant's rights, and, in felony cases, advise the defendant of the next steps in the process, which is the preliminary hearing. So the magistrate then sets a date for the preliminary hearing, which the defendant may choose to waive. The magistrate judge then will ask the defendant to enter a plea. If the defendant chooses to plead not guilty, the judge will set a trial date. Defendants are entitled to have counsel present at every stage of every felony criminal justice proceeding. If the person can't afford counsel, the court will provide a court-appointed attorney. Now, a substantial percentage of all felony defendants go through their criminal justice proceedings with court-appointed counsel. These attorneys may work for a public defender service or they may be in private practice, but they make themselves available to represent a limited number of indigent people. Now, as a practical matter, the indigent defendants who use court-appointed counsel do not have much choice about which attorney is going to represent them. So what about bail? You've all heard that we all have a right to bail. Well, if the defendant is in custody at the time of his first appearance, one of the most important functions of that proceeding is for the magistrate judge to determine whether bail is appropriate. Bail establishes the conditions under which the defendant can be released from confinement until his case is decided. If the magistrate judge agrees that the bail is warranted in the case, he may require the defendant to post bail in cash, with a surety bond, or by signing over a deed to property. But in many cases, the judge can accept the defendant's personal guarantee that he will present himself at trial. Now, in general, the magistrate is expected to impose such bail conditions as appear reasonably necessary to assure that the defendant will make a court appearance as scheduled throughout the criminal justice proceedings. And there's a presumption that the defendant is entitled to bail. But in reality, that isn't the case. Particularly in drug cases or other serious offenses, judges will frequently refuse to release a person on bail. Ask me how I know. The magistrate generally looks to the seriousness of the crime, the defendant's criminal history, the defendant's risk of flight, and the defendant's ties to the community when deliberating over the appropriate bail conditions. So, we next go to the preliminary hearing. After the first appearance, the next scheduled step is the preliminary hearing. Defendants who choose to plead guilty frequently waive the preliminary hearing. Some jurisdictions allow the prosecutor to bypass the preliminary hearing, which is yet another screening of the charge, by immediately obtaining a grand jury indictment. In jurisdictions that allow preliminary hearings, magistrate judges preside over the first step. But since this phase of the process is adversarial in nature, the defendant should definitely have counsel there to represent him. And generally, during this proceeding, the prosecutor will provide the witnesses and the defense counsel with an opportunity to cross-examine the witnesses. After listening to the proceeding, the magistrate judge will determine whether to advance the case to the next level, which is a grand jury review, or the filing of a criminal information or complaint. So here we go to the grand jury review. In the federal system, all felony prosecutions require a grand jury review. Is that accurate? Let me write that again. All felony prosecutions require a grand jury review? I don't know about that. The only exception, here we go. The only exception is when the defendant waives this review and agrees to be charged with a criminal complaint or information. I knew it didn't make sense there, but I wrote this a long time ago. So states vary in their requirements for charges. The primary function of the grand jury review is to determine whether sufficient evidence exists to proceed with a trial on the criminal charges. Now, a number of randomly chosen citizens sit on the grand jury panel. It's usually between 12 and 23 people. And those grand juries listen as the prosecution presents its case. And the prosecution uses its subpoena power to call witnesses before the grand jury. Then they question the witnesses under oath. Witnesses don't have the right to legal counsel during the grand jury proceedings, and there is no cross-examination. So accordingly, the proceeding is really a one-sided show for the prosecution. But when the prosecution does persuade the grand jury that there is merit to the criminal charge, the grand jury returns an indictment. And although the grand jury is said to be a screening device, many in the legal profession ridicule it because they know that a defendant can't speak on his own behalf, and targets don't even know the prosecutor convened a grand jury. Prosecutors have their way. They get to build arguments without giving the target an opportunity to respond. And so for that reason, prosecutors could use all of their persuasive powers and skill to persuade or influence a body of citizens that are generally don't understand the criminal justice system that it's time to return an indictment. So, prosecutors choose to indict a person is generally going to happen. And that would bring the arraignment on the criminal investigation, the complaint, the information, the indictment, whatever the charging instrument the prosecutor brings forward, there's going to be an arraignment. Now, after the accusatory instrument is filed with the court, the defendant comes before the trial court and the judge reads him the charges against him. He asks the person, how he wants to plead. Now, ordinarily, the options for the defendant are to plead guilty or not guilty. This procedure is known as arraigning the defendant. It's pretty much a perfunctory matter. In most cases, the defendants are going to plead not guilty at the earliest stages. And this strategy is really to give the defendant more time to examine the strength of the government's case. Remember, in a criminal case, the prosecution has to prove the case beyond a reasonable doubt. Or as my judge says, not beyond all doubt, just a reasonable doubt. So the procedure is just really to assess, can the prosecutor prove the case? That's what this arraignment goes through. So after the person's been arraigned, the next step is the plea bargaining or the proffers. Plea bargaining is really a normal part of the criminal justice proceedings. Prosecutors want defendants to plead guilty. Ultimately, they want a conviction. Trials require substantial amounts of government resources and time. And further, the outcome of the trial is uncertain. So, prosecutors frequently will grant concessions to induce the defendant to plead guilty. For example, they may agree to dismiss certain charges, or they may agree not to prosecute a family member. The prosecutors want to avoid the time and the expense of a trial, so they may invite the defendant to a proffer where they would show what they could prove in a trial, or the prosecutorial team may proffer what it could prove. It may look for the other side and have the defendant come and show, well, why shouldn't we charge you with a case? The prosecutor has the authority to charge the person with a crime that carries certain sentences, but they also have the ability to recommend certain sentences within a statutory guideline range. And in the end, the judge is going to impose the sentence. Although the judge may listen to the prosecutor's sentencing recommendation, prosecutors don't have the power to bind a judge's decision. The vast majority of defendants have to face a sentencing hearing because most plead guilty. Frequently, defendants that plead guilty spend much of their time in prison second-guessing their decision. And experience convinces our team that defendants who know they are guilty are vastly better off to accept complete responsibility, to express remorse, to plead guilty at the earliest possible stage, and to work toward an effective sentence mitigation strategy. We write a lot about that on our websites at Prison Professors or at Resilient Courses. Like all decisions where liberty is at stake, deciding whether to plead guilty is a legal decision that a person should make with the assistance of counsel. But a person also has to use common sense. Think, because you know the situation better than anyone. So what happens next? If you're going to go to trial, there are a series of pretrial motions. After the arraignment, the attorneys for the defendant are going to choose to file multiple pretrial motions before the trial court in an effort to help them develop this better understanding of the government's evidence. That's the discovery process. These motions may attack the charging instrument. They may ask for an order directing the government to disclose evidence. They may request the court to suppress evidence that they may believe, that the attorneys believe were obtained by violating the person's constitutional rights. And if after all that discovery process, there's not been a settlement, well then a trial is going to unfold. Now the trial, if the case has not been dismissed and the defendant has not pleaded guilty, is the big step. It's the fact-finding mission. So defendants have a right to a speedy trial, but the defendant can also waive that right, and most of them will. The prosecutor may look for excusable opportunities to extend this pretrial period, or the defendants may do it. But both sides of this adversarial process look for every opportunity to prepare their case. In a typical jurisdiction, it is reasonable to expect 5 to 10 months to pass from the time of arrest to the time that the trial begins. Some trials may require only a few hours, others several weeks. Complicated cases may stretch several months or even years before both sides present their closing arguments. Now, although some defendants choose a bench trial with only a judge to determine whether the person is guilty or innocent, all felony defendants have the right to a jury trial. And in a jury trial, a group of randomly selected citizens, that's called the petite jury, is charged with the responsibility of listening to the evidence that the trial judge allows to be presented. Remember earlier I spoke about a game with both sides? Well, the jurors are going to be like the referees, and the judge is going to determine what they can consider. The jurors are supposed to presume the defendant is not guilty of the charges until the trial judges instruct them to begin deliberating or where the prosecution has proven its case. But the trial doesn't always work out that way because we're human beings and we make judgments. It all begins with this voir dire process, which is questioning of the jurors, trying to find out if they can be unbiased. And this theory holds that they're trying to find somebody that's unbiased, but frankly, I don't know how likely or realistic that is. Once the jury, gets called in there and it's the United States of America versus, in my case, Michael Santos, right? It's kind of hard for a jury to look at me in the same way as if I'm the person's next door neighbor. They automatically see me as in a biased way. And so, then comes the opening arguments, and the prosecution begins presenting its case, usually with live witnesses, and then the defense may cross-examine. Then the prosecution will rest, and the defense will have an opportunity to present its case, and the prosecutor can cross-examine the witnesses. And after both sides have rested, the prosecutor is going to make a closing arguments. Then the defense attorney is going to make closing arguments. Then the prosecutor is going to get the last word in response to what the defense attorney said. And then finally, the judge is going to read a set of instructions to the jury. And only after the judge releases the jury to deliberate on the case are they allowed to even be thinking about it. That's in theory. Now, to obtain a conviction, each member of the jury must find the defendant guilty beyond a reasonable doubt. Now, once the jury reaches that verdict and it's announced in court, the judge concludes the trial. If it's a guilty verdict after the trial or the result of a plea, a series of post-convictions proceedings are going to follow, which I'm going to cover in the next chapter. We'll offer a lot of insight on post-conviction proceedings and sentencing and all that other formal procedure that follows. Well, so I got through this entire chapter with one take. So I'm not going to do much editing here. I'm just going to let it flow. I actually recorded it both on video and in audio because I wanted to share it with our Facebook audience and our YouTube audience. And I wanted to kind of show them the amount of work that has to go into the work that we do at Prison Professors. And that is, just always trying to provide as much content as we possibly can and to demonstrate that we're 100% authentic. We're for real. We really work hard to try and help people understand court, sentencing, and prison. And more importantly, we try to help people understand what they can do to prepare for a successful journey or a successful outcome, regardless of where they are. I work together with my partner, Justin Paperny. If you want more information, please visit our website at Prison Professors or White Collar Advice or Resilient Courses. Listen to our iTunes podcast at Prison Professors on iTunes. Where else can you reach us? Obviously through our websites. Or you can give us a call or a text at 949-205-6056 because we are here to help people get the best possible outcome, and we hope that we're helping you. Back tomorrow with another episode. Thank you.